my name is indeed Lawrence Dauwe. I'm a partner at Osborne Clarke, and I'm specialized in tech transactions and cybersecurity. Now, as part of our session of today, we're going to talk about some new legal trends and the impact of these trends on businesses. Now, probably you've already heard that over the last 5 years, the European institutions have created some form of tsunami of new regulation. We see that there is a vast increase in tech regulation in certain specific areas of expertise. First and foremost, the European institutions, they tried to govern data. Now, when it comes to personal data, everyone is familiar with GDPR. But on the back of that, the European institutions also tried to regulate data that were generated by IoT devices, and that's where the so-called Data Act comes in. It also tried to govern and manage data from public authorities, and that's where the Data Governance Act comes in. Also, cybersecurity is a really hot topic. Now, for those of you who are active in the financial sector or provide services to the financial sector, typically you've already heard about DORA, the Digital Operational Resilience Act. It sets forth a framework that you need to comply with when you're providing IT services to financial entities. On the back of that, we also see, for instance, NIS2 directive, which essentially aims to create a harmonized level playing field for cybersecurity in certain industries, for instance, nuclear power sector or waterways and so on. Also, platforms have been regulated. I don't know whether or not some of you are active in the hosting business or operate a social network or operate an online marketplace. Well, that's where you fall under the so-called Digital Services Act. And that Digital Services Act actually builds further upon the E-Commerce Act that date back to 2000, and now it aims to address illegal content and the dissemination of illegal content online, right? And last but not least, the crown jewel of the European institutions was the so-called Artificial Intelligence Act. It was recently adopted, it's not yet published, but it will be a vast challenge to implement it in reality, right? Now, what are the trends that we're seeing in practice? Now, as a lawyer, I assist larger tech companies, but also smaller tech companies. And what we see, regardless of the size of your company, well, in reality, these regulations, they apply regardless of the size of your company. Even if you're a Meta, a Microsoft, or Capgemini, or what have you, you will need to comply, as well as if you're a smaller company, you also need to comply. And we see that many of these companies, they are really struggling with following up on these regulations, because in reality, it's just too much, right? Second issue that we're seeing is, for companies, it becomes really difficult to comply with these regulations. These regulations, they generate a certain cost. I was talking earlier with some of you here in the audience on the compliance cost, and these regulatory red tape really creates a substantial increase in the cost structure of tech providers. At the same time, we also see that in reality, regulators are actively enforcing compliance. And this is becoming problematic because there's not a day that goes by that the Dutch Consumer Authority, the French or the German Consumer Authority are actively enforcing compliance. At the same time, we also see that, for instance, data protection authorities in France, in Spain, in Italy are imposing fines on a daily basis. So this really creates massive challenges for tech providers. And on the back of that, in terms of the queries that we are recently receiving from a legal perspective, we typically see that the majority of the queries are related to AI and data. Now, luckily, I'm here with an audience that is completely tech first, so I don't need to explain how AI works. So as a mere legal, that's a good opportunity for me. But when we're talking about AI, well, AI all revolves around data, right? Data is the oil of the AI. It's the lifeblood of AI. You use data for training your model, you put data in your model, and you get data out of it. Now, in reality, well, when you're working with data, especially, for instance, if you're training your LLM for generative AI solutions, then there are certain risks that you need to factor in. One of these risks is intellectual property right. This is often overlooked, but if we take the example of OpenAI, well, OpenAI works on the basis of a large language model. It has used all available information on the internet to create its LLM model. What we see now is that some newspapers in the US, they wanted to have additional revenue streams, and now they argue, look, OpenAI, you have used my news articles, as part of the training of your model, now we're going to sue you, and that's where the case for the New York Times against OpenAI comes in, and now all major US newspapers are essentially suing OpenAI. And essentially, this type of litigation, that the IP aspect, can have a massive impact on the viability of these types of LLM solutions. Also, data protection is a real issue. For those of you who are working with AI, if you're training your model, please abstain from using personal data for the training of your model. This is particularly the case because personal data falls under the GDPR, right? Under the GDPR, if you want to use personal data, you need to have a legitimate basis. In practice, you will not most likely have such legal basis. So if you do so, 9 out of 10, you would be in violation of the GDPR. This is something that you definitely need to avoid, right? And we see a lot of our clients who are active in the life sciences sector that have issues in relation thereto. Also, when prompting, so when giving instructions to a generative AI solution, you need to be mindful of confidentiality. Now, I know in the audience, there are a number of developers, and some of them, they use, for instance, Amazon Code Whisperer, right? Or GitHub Copilot. Now, if you put, for instance, client code in these solutions to embellish the code, 9 out of 10, that client code is divulged to you under a confidentiality agreement. If you put that in a publicly available generative AI solution, you're violating essentially contractual confidentiality obligations. So this is something that you need to be aware of, right? Also, in terms of outputs, there are certain risks that you need to be taken into account when using AI solutions. First and foremost, and it's a misconception that I often see with a lot of clients, many clients believe that if you put data into an AI solution and you generate an output, that output is copyright protected. 9 out of 10, this is not the case. Why? Because something is only copyright protected to the extent that it's first and foremost materialized, but also original, meaning it's the result of the author's own intellectual creation. Since the solution is the solution that creates essentially the output, obviously, you most likely won't be able to claim copyright protection. So this is something that you also need to take into account. The same goes with IP infringement. Once again, if we take the example of Amazon Code Whisperer or GitHub Copilot, well, these models are trained on publicly available information that we can find in GitHub or SourceForge or whatever. But in many cases, the code that is used to train these models was open sourced, but there are certain licenses for open source, right? If you reuse that code in your client project, then there is a risk that you could violate third-party intellectual property rights. So this is really important to manage that type of risk, all right? Now, I have raised certain legal issues, but you should never raise a legal issue without coming up with a solution, right? Now, in terms of managing training data, well, first and foremost, if you're developing your own LLM model, make sure that you're not violating any third-party IP rights or using personal data, right? If you're using a pre-trained LLM, then typically check the license terms. Check whether or not there are representations and warranties in there with regard to data protection violations and IP. If not, there's a high probability that it's trained in violation of IP rights, right? Secondly, when prompting, avoid the disclosure of confidential information. And we have a lot of clients that are using tech clients that are using publicly available coding assistants, and they are asking, how can we manage that? Typically, we manage that by training the development teams, first and foremost, and also including certain policies within the organization on the appropriate use of Gen AI. What we also do, for instance, for companies that are using Code Whisperer or Copilot or whatever, for the development teams, we get a bullet point list of 10 key points that they need to do, just that the developers know what they can do and what they cannot do with using or when using such solutions, right? Also, AI generates output, but AI, specifically generative AI, is not exact science. This means, in fact, that you need to understand that the output is 9 out of 10 not entirely correct. It's your responsibility as a user of AI to make sure that you take responsibility of the output of that AI solution and that you include appropriate reps and warranties and liability disclaimers in your contract with regard to generative AI content, all right? Now, I can't talk about AI without briefly touching upon the AI Act. Now, the AI Act, it's a massive piece of legislation. It's over 490 pages, so you will appreciate that I won't be going into the details of AI. But what is it actually? Now, the European Union actually wanted to create a framework in order to ensure a trustworthy, transparent, and safe use of AI within the European Union, right? Now, how has it done that? Well, it used what we call a role-based and risk-based approach. Now, with regard to that risk-based approach, if we discern the AI Act, well, it distinguishes between general-purpose AI solutions. These are pre-trained models, for instance, LLM models, that you can use, but the regulatory obligations are fairly limited when it comes to general-purpose AI solutions. But on the other side, you have so-called AI systems, and there's a classification of AI systems based on the risk that they are posing. For instance, we have prohibited AI. What is prohibited AI? A good example is social scoring mechanisms. We all know the situation in China, where you can go on the street, and if your social score is too low, you can't get an insurance. That's prohibited in Europe. Same goes for biometric monitoring, for instance. You can use IMPR cameras, if you want to, with AI to follow a person throughout the entire city of Ghent. That's prohibited in Europe, luckily, probably, right? At the same time, you also have like high-risk AI systems. And what are high-risk AI systems? AI systems which contain a safety component. Suppose, for instance, that you have a train management system that is based on AI, for train steering, for instance, that will qualify as a high-risk AI system. There are still other examples. They are set forth in Annex 2, of the AI Act. I'm not going to go in detail, but for instance, if you want to embed an AI option in a toy, for instance, if Mattel wants to embed AI in a toy or in, let's say, a TV, then typically it will be considered a high-risk AI under the AI Act. And the last category is limited risk. Now, aside from the risk-based approach, you also have a role-based approach. And the obligations under the AI Act depend on, first of all, the risk that your AI system poses and the role that you assume. And there are different qualifications. For instance, if you are OpenAI, then you have created an AI solution, you are the provider. This means, in fact, that the majority of the obligations under the AI Act will apply to you. But if you, for instance, as a tech company, you're deploying Code Whisperer or Copilot or what have you, or DALL-E, then you're using it in your service delivery towards your clients, then you're a deployer. So in that case, the regulatory obligations will be far less. Suppose, for instance, that OpenAI is not commercializing its model, but asks you to commercialize its solution, then you are an importer, distributor, and then there are other obligations applicable to you. And in the example of, for instance, the toy company that embeds AI in its toys, then they are the manufacturer. The same goes, for instance, if you want to have a self-driving car with an AI solution in it, then you will be the manufacturer, and then different obligations apply to you. Now the question obviously is, what are the obligations? There are many obligations, unfortunately, under the AI Act, which makes implementation not that straightforward, but the key obligation is, first and foremost, you need to implement what we call a risk management system. This is an evaluation system, an evaluation matrix that allows you to determine what the qualification of your system is, what the risk profile is of your system, right? If you're performing AI or data processing with your AI solution, then you will definitely need to do a data protection impact assessment, which is fairly straightforward. I think most of you already know what that is. Now, AI revolves around data, right? Data is the lifeblood of AI. Now, obviously, you must make sure that that data is of a sufficient quality, because if the quality of the data is not good, obviously the output is also not good. And this could lead to incorrect conclusions, right? So the AI Act imposes a data management procedure and a data governance framework that you need to implement. And last but not least, AI needs to be explainable, right? This is one of the key principles of the AI Act. You need to be able to explain what AI actually is, and that's why they impose certain documentation requirements of AI, and typically this is fairly difficult to do, right? Now, second trend that we're seeing is data, right? The regulation of data. Now, when we're talking about data regulation in the EU, there are three key pillars. And the first principle, the first pillar is fair. Data must be findable, accessible, interoperable, and reusable. And in that context, for instance, the European Union has created certain mandatory licenses, FR&D licenses, fair, reasonable, and non-discriminatory licenses. We also see that, for instance, for those of you who've already heard about it, common data spaces, which are European data spaces hosted at Gaia X primarily, where, for instance, all mobility data from European institutions is collected and all health data is collected. That is an implementation of that FAIR principle. Second principle is data must be trustworthy and must be secure. Right? And that's where the GDPR comes in, because essentially it's a framework that enables the exchange of personal data in a secure and trustworthy manner. And last but not least, in terms of data, European institutions try to avoid the creation of monopolies, right? Because in Europe, free movement of goods and services is one of the key principles. And that's where the European institutions have recently adopted the the Digital Markets Act, by which companies like Apple, like Amazon, etc. are governed, whereby the European Commission is now intending to fine Amazon 1.8 billion euros for non-complying with the DMA. And on that back, we also see the Data Act, which essentially aims to govern the use of data that is being created by smart devices, IoT devices. It's also relevant for cloud providers, honestly. And I'll be coming back to that later on. Now, when it comes to GDPR, well, despite the fact that GDPR is already almost 10 years old, unfortunately, we still see a lot of GDPR issues. We still see a lot of challenges of GDPR. In reality, when I'm negotiating with clients, when we're trying to sell a client product, typically we still have a lot of issues with DPOs and compliance people when it comes to GDPR issues. But in reality, in many cases, GDPR issues often result from a lack of understanding of certain of the core principles of the GDPR. Also a lack of understanding of the solution that the tech provider is offering. At the same time, we also see a lot of queries regarding GDPR due to data breaches. We see lately that there's an increasing amount of data security incidents, and which result obviously in data breach notifications, which obviously also creates a lot more work in terms of GDPR compliance. Now, in reality, I think you're already quite familiar with GDPR, but I think GDPR compliance is definitely not straightforward, but you can be compliant, but you need to have the right partner. And I think for those of you who are tech providers, I think it's important to have an understanding what GDPR is and try to, when you go to market to your client, be aware of GDPR implications, because it facilitates your go-to-market. When I'm acting for a client who is buying tech and I'm sitting around the table with a tech provider who really understands or who has a notion in terms of GDPR issues and regulatory issues, it really facilitates the go-to-market. So that was my advice in relation to GDPR compliance. Now, another aspect is the Data Act. The Data Act, as stated earlier, it's an encompassing act that tries to avoid the creation of monopolies with regard to data. We all know back in the day, a few years ago, when IoT was a big thing, that many of these providers tried to create their own data ecosystem, right? So they wanted to create a lock-in scenario where they obliged their client to stay within their own ecosystem of IoT devices. And the European institutions try to avoid that by imposing the Data Act. What is relevant in the Data Act? Well, it obliges data sharing obligations. So meaning that you can, as a user, ask the provider to share certain data with third parties, right? There are also obligations from data providers, data holders as we call them, to provide certain data to public authorities in cases of exceptional need. But what is relevant, more from a cloud perspective, is that at some point in time, the European Commission realized that there was a lock-in effect of certain cloud providers. At the end of a contract, certain cloud providers refused to hand over the data. There have been in the past certain cases in Europe where a lock-in effect was created, and the European Union wanted to avoid that. And that's where they implemented Article 24 and following of the Data Act, which essentially obliges a cloud provider to facilitate cloud switching services, meaning you must, as a cloud provider, enable your client to migrate from your services towards similar services provided by a third party. Now, in reality, we have had certain clients that have questions in relation thereto, but typically, for us, this is a no-brainer. If you're acting for a cloud provider, providing exit assistance and exit services, this is something at Cloud Sisters, we're doing it already and for years. So this is something which for us is a no-brainer. But I think it's important across the board that people are mindful of that specific aspect. Now, to conclude, what are the key takeaways based on what we see on a daily basis? Well, for us personally, the regulatory tsunami is really challenging. Challenging for our clients, but also for us personally, because I'm not able to follow up with every legal regulatory innovation that the European Commission comes up with, right? But I think for a tech provider, it's first and foremost really important to understand the own regulatory obligations that are applicable to you, obviously, but because it forms part of your core business. But also, if you're trying to focus your services towards a certain sector, try to be mindful of some of the regulatory obligations that apply to that sector. If you're focusing your activities towards the public sector, understand what the requirements more or less are in the public sector, same for the financial or healthcare industry. Because in reality, based on experience, if you want to have a go-to market, understand the sector, and honestly, it's your entrance ticket. So that's my key takeaway. Thank you.